More paperwork has just been submitted in the Ripple SEC lawsuit. It wasn't a summary judgment, though. I want to explain what was recently filed in this video and how it will affect the case moving forward, because many individuals, particularly lawyers in this community, believe that this particular filing will help Ripple conduct significant damage control in the future. In addition, I'd like to discuss when we might actually receive a summary judgment decision. After all, we do have opinions for both John D. and Jeremy Hogan. Make sure to stay tuned for that because you won't want to miss it. We'll also discuss in this video when Judge Torres will eventually decide who wins this case. And I'd like to begin with the most recent file that was made in the Ripple SEC lawsuit. Also, Ripple filed this document, referencing the Voyager Binance SEC fiasco. And I talked a lot about this on the channel. To briefly recap for those of you who missed it, Binance was attempting to acquire Voyager, a bankrupt exchange, and the SEC was attempting to block the transaction by alleging a possible securities violation. In order to win the judge's support, the SEC refused to specify what the securities infraction was. Sadly for the SEC, this judge railed against the organization non-stop during the session. The SEC has never given the market any certainty, according to the judge's major rationale. But how would anyone be able to detect a securities violation? It was made very plain by the judge in this instance that the SEC had not made any clearer pronouncements regarding cryptocurrencies, and therefore it would be absurd for the SEC to intervene in one of these transactions and claim that it is obvious that a securities law has been broken. Simply put, it's unnecessary to make it public. The judge is finally catching on to what the XRP community has been saying about this case since day one. The regulations are not clear, and the SEC can't just do anything they want. This is why we believe it breaches securities laws. When Ripple filed the wording the court was using in response to the SEC's lack of clarity in that case and stated, "Look, this is exactly what we're talking about. This is actually pretty crucial to the Ripple SEC case. We claim that the SEC never provided us with adequate notice. We were never informed by the SEC that XRP was a security. If anything, by mentioning Ethereum and Bitcoin Warren, they made it abundantly clear that XRP probably wasn't a security. Ripple will file this in this case and provide it to Judge Torres. Hey, you're not crazy if you believe that the SEC has performed poorly in its role as a regulator. Well, this other judge concurs with you. And what this actually accomplishes is that it removes many charges from the table. At this point, move on. The SEC individually prosecuted Brad Garlinghouse and Chris Larson in the lawsuit they brought against Ripple, claiming that these two obviously knew they were breaking securities laws and did it anyway. This indicates this is not at all the case, and there is no way they will be held accountable. Moreover, this charge will not proceed. John Deaton has already stated that he is confident the FCC's accusation is unfounded. This also eliminates a significant amount of punishment that Ripple may otherwise face if they actually lose the case. What we're finding out is that some Ripple sales may have involved securities transactions, even if the judge does agree. In essence, this shows that Ripple won't receive much punishment, because nobody was aware of the rules. The SEC was scheduled to issue regulations informing Ripple to reconsider its course of action and perhaps carry it out in this manner. This was not at all done by the SEC. And this is simply another piece of evidence that the XRP community isn't the one saying these things. In reality, judges in other cases have reached the same verdict. And what's really amazing about everything is how limited and weak the SEC case is becoming with each and every new piece of evidence that Ripple is adding to the case. Just so you know, the SEC hasn't even been reacting to these complaints, despite the fact that they probably realize they overreached with Ripple and that some of this may be beyond their reach. Now that we've covered a lot of the case's current status, I'd like to go on and show you an update that I just saw from John D. And rather than my attempting to explain anything, I'd just like to show you this film, as it was fantastic and will help to clarify many crucial issues. Listen carefully, and then we'll explain it. But if that happens before the end of this week, I wouldn't be shocked. And I work like this. I base my decisions on her past actions. If you examine some of her earlier cases, you'll see that she occasionally rendered the summary judgment decision concurrently with the daughter. She once rendered several erroneous judgments at once. Because of this, after the dollar motion was denied, I stated that summary judgment may be granted today. Nevertheless, after 2 weeks had passed since the Doorbird rulings in another case, she finally decided to grant summary judgment. Although I'm speculating, I can tell you that I would be very shocked if it wasn't within the next 30 days, because there was an instance where she made the dog judgment, and there was a 60-day gap. If it's past due, it would be inconsistent with the manner in which she has handled cases if April arrives and we are still waiting. Back then, when the summary judgment ruling for Ripples was released. This is a brief written for the appellate courts, which I announced when I came out. The U.S. Supreme Court and the Second Circuit were then immediately addressed in a letter. You can see that an appeal has already been prepared, and Brad Garland House even claimed that Ripple was acting as if they had already lost. Do you recall when he said it, I wonder? And he said, listen, it's not going to be any worse first than it is now. In essence, if you look at who they employed, Michael Kellogg was one of them. Well, the best appellate lawyer in the United States of America is Michael Kellogg. You still work as a partner for Mike Dillard, okay, and Neil Gorsuch, who is a member of the Supreme Court. Also, he formerly served as the Chief Rehnquist Clerk and the Solicitor General. This brief is intended for the appellate courts as a result. And I've publicly stated that Ripple will win if the case is taken to the Supreme Court. I'm quite certain when I claim that I'm certain of something 100%. There aren't many things about which you can be certain. Regardless of your opinion of it, the Supreme Court's decision to overturn Roe v. Wade invalidates a precedent that had been in place for 50 years. Justices and judges who are conservatives exist. And if you take a look at the recent EPA v. West Virginia case that Professor J. W. and I discussed, that is the case where they chastised the EPA for extending its jurisdiction without congressional authorization. So that's a federal agency, which sounds familiar. Additionally, Michael Kellogg and his company are experts in regulatory and appellate matters. However, if the SEC were to win completely, which I don't believe will happen, but if they did, this would undoubtedly be appealed. Ripple will simply carry on with business as usual while we wait and see if the appellate court rules in their favor. For what I just mentioned, the SEC currently has the best prospects with Judge Torres at the U.S. District Court. In a nutshell, the reason Ripple would appeal is if Ripple wins the case, the SEC threatens to appeal, and then uses the appeal to reach a settlement with Ripple Labs, making the SEC seem good in the process. As the final piece of the puzzle for Ripple's complete worldwide coverage, Ripple eventually gains the certainty it needs to ultimately offer up its on-demand liquidity solutions in the U.S. corridor. If Ripple prevails, Gary Gensler won't be working for the SEC in several years or 5 years, especially if the case ends up in the Supreme Court. Of course not. Hence, if you already know that you're going to lose on appeal with a high degree of probability, you can secure a political victory now. What do you anticipate Gary Gensler doing? What I mean by a political victory is that the SEC would only have the threat of an appeal if they were to lose. Do I believe they will threaten to challenge it then? Sure. They would then attempt to negotiate a settlement under the threat of an appeal. If you agree to pay $25 million, pick the right number, and Ripple may very well entertain that. Then, after Judge Torres' ruling, when they get to say, okay, Ripple will get it. We'll waive our appeal and agree with Judge Torres' decision that secondary market sales are not securities and that your ongoing and future sales are not securities. Good sir, you might affirm that we achieved victory and received many millions of dollars. But more crucially, he is free to pursue his other objectives in the present. The problem is that Lutterat further claimed that the SEC is stepping up its enforcement of cryptocurrency laws. Even though they increased the SEC's crypto enforcement a year ago, they did so today. Why then would you accept the chance of losing by appealing? When might you achieve that political victory, you ask? What an excellent issue John posed. Why would the SEC double its staff, particularly in its area for cyber and crypto assets? Unless they already know that Ripple will triumph? I'll go a step further and ask you to consider this in light of Tony's Coinbase interview with the Thinking Crypto channel. If Ripple prevails and Judge Torres rules in favor of Ripple, you wouldn't be able to demonstrate that the firm that actually owns 50% of the tokens offered XRP as a security. Do you believe that will inspire confidence in Coinbase and Kraken? If you're unable to convince Ripple of it? When Coinbase, Kraken, or Uphold sell it, are you really certain that you can't show that it is a security? Then why? I'm aware that Coinbase chief legal officer stated, and he's going to say there's a publicly traded company. He's going to say we have to be careful, we've got to do this. We must carry it out. Just use common sense though. If you lose your case against Ripple and are unable to show that Ripple broke the law, you can be sure that Coinbase or anyone else is not guilty of the same crime. I believe it would also be fantastic news for the retail industry. John goes further than that. Hinman's communications were brought up in relation to a topic that the SEC has refused to address. I must admit, I already said that in public. The emails will eventually become public. Thus, aside from the shaky camera, I genuinely believe that was one of John Deaton's best interviews to date because he addressed several crucial concerns. He and I appear to be in agreement that the Supreme Court will not hear this issue. Although the SEC may threaten to do so, they stand a very good risk of losing even more severely there. Hence, it is not really logical for them to go that far. He believes that the SEC will merely use threats to press for a settlement. Whether or not that will occur, the SEC will accept summary judgment and move on, or this matter will settle after it, whichever comes first. It appears that he and I are in agreement that the case will most likely be resolved quickly. More noteworthy, in my opinion, is his belief that the decision is just around the corner. He predicted it would occur last week. In addition, Jeremy Hogan claims that he predicted it would occur last week and that, on a scale of 1 to 10, we are extremely close. A verdict in this case is just around the corner. Never before has Ripple looked better. The SEC has lost nearly all of its significant cases. They're going to lose yet another important decision, in my opinion. There is no likelihood, in my opinion, that XRP will be recognized as a security. Watch to see if Ripple receives a warning or if the SEC loses everything. In any case, I am incredibly sure since we are only around the corner. Nevertheless, I really appreciate your being here. I hope this update was enjoyable. Please remember to like and subscribe if you did. For the time being, it truly means a lot. Mikkel's gone.